What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy hump day. I've got some court. You guys want to watch some court? I want to watch some court. Let's watch some court. All right. What do I have tonight? First case. I'm just going to say this about the first case. You guys know my feelings about sharing family law cases. I don't like doing it. Usually, my only exception is sovereign citizens, or we get just a giant Karen. And well, yeah, we're gonna go with the latter in this one. You know what? I'm not gonna say anything else. If you have seen it and you're in the chat, please do not spoil it. I know it's started making its rounds already, but it's good enough. I had to throw it on the video. I have to share. You guys are gonna enjoy it. And then let's see. We have got another Karen. And then we have a couple Judge Simpson clips. So that's what's on the docket for this evening. I hope you guys enjoy it. You know what? Let's do it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Okay, we are on the record for case number 2024-1372 DC. Zachary Conley versus Athena Couch. Today is Wednesday, March 12th, 2025 at 8:54 a.m. Attorney Michael Kelly's for the plaintiff.
Okay. Good morning to everyone. This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the, we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection. That focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it. Which leads me also to the moral fitness of the parties involved, which ties into the same factor. But we have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, or we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved as well as the stable, satisfactory environment, in that she's accusing him of sexually molesting these girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not gonna facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's gonna take these kids and run, and we're gonna be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The next statement is also false. On December 27th, after the children's bath, Amelia Conley was heavily touching her private area, and when questioned who touched her potty, she said her dada. On January 1st, Evelyn Conley stated that her dad touched her on the couch. The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8. It's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. And I withheld the children again after finding videos the plaintiff had watched of children being abused. And the minor children were sexually abused during holiday parenting time with the plaintiff. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support, and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation. That's all.
Okay, thank you. I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings, obviously you're well aware of the file in this case.
Mike was on my head. I gotta pause it for a second. Yeah, she doesn't get to do that. See, with all the investigations, CPS, the police, yeah, she doesn't just get to do that on her own. This is why she's in trouble. She could strongly believe all those things that she just said are factually correct. It doesn't matter. The police, Child Protective Services, they haven't found anything to solidify your points at all. So yeah, sorry, lady.
The court does believe that the plaintiff has met the Vavarka threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client? Okay,
Certainly can. I have another witness that I could call as well. I just have two.
okay. Whichever you want to do first, go ahead.
I can have Mr. Connolly
Okay,
testify.
Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure. We'll keep it straight and to the point here.
All right, raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yeah, that guy doesn't look like a hot grandma to me. I mean, to each their own, but yeah, that's not what I think of when I think of hot grandmas. Sorry, John.
Go ahead and have a seat, sir. Go ahead, Mr. Kelly.
Mr. Connolly, could you state your name and spell your last name for the record?
Zachary Donald Conley, Conley.
Are you the father of Amelia and Evelyn Connolly in this matter?
Yes, I am.
Okay. You currently have parenting time with them.
Yes,
What is your understanding of what the parenting time is supposed to be?
every other weekend and a day during the week, in the evening. Not my weekends, it's Wednesday through Friday.
Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
And when you say she, who are you referencing?
Athena Couch.
Okay. Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes.
Most
I'm sorry yesterday was a bad day for you, Sandy. Hopefully today was better. And yeah, come on, let's watch some court. I want to watch some court.
recently, did the court award you parenting time in January of this year?
Yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No? Okay, thank you. You may step down then, sir. Next witness, Mr. Kelly.
Your Honor, we would call Lori Connolly.
Okay, Ms. Conley, step forward, please.
Lori Putnam, Your Honor.
Okay. You're gonna make me change my.
All right. Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes,
Ma'am, could you state your last name again?
Putnam,
Spell.
Putnam.
Okay, thank you. Go ahead.
Ms. Putnam, how do you know Mr. Connolly?
He is my son.
And how do you know Ms. Couch?
She is Zach's former girlfriend and the mother of my granddaughters.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I do.
parenting time? Okay. What do you do in that regard?
I go with him and walk up to the door with him. To get the girls,
Okay.
to attempt to get the girls.
Has there been occasions when you have gone with him to go get the girls? And anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park. And we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was, I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was gonna refuse to give the girls.
And have,
Yeah, absolutely. The court can hold you in contempt for every single breach of what the court orders. So even if it was just one day, the court could hold you in contempt for not allowing the father to see the children just one day. I mean, they could. It's highly unlikely, but they could. It's just like I mean, it's a contract. It's a contract that both parents sign with the court. So every single breach, you are liable to be held in contempt.
you've gone with him on subsequent occasions to attempt parenting time?
Yes.
Okay. And what has happened on those subsequent occasions?
Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
No further questions.
Okay, hold on, ma'am. No, you're not done. Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time. And that stated that the parenting time would oops. That the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
Okay. Okay. And you don't remember if she was not there?
Megan, thank you so much for the raid, my friend. I appreciate it. Welcome to all the Bacon Raiders. You guys actually came in at a good time because the first part of this is kind of slow and it's about to pick up. But this is a very interesting case where mom finds herself in a lot of trouble. So yeah, if you've already seen this before, please don't spoil it. I know it's made its rounds. It's been on a few channels already today, but so no spoilers if you've seen it. But it's about to go down. Thanks, Megan.
He refused.
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay, Ms. Couch, do you have any questions
I
of
do,
this witness?
yes. Um. At what age did Zach Conley start wearing diapers?
And Judge, I'm gonna object to it.
Ma'am, that is not germane.
No, I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, et cetera. Okay?
Okay,
Go ahead.
and you were at my residence on the 27th to pick up the.
What was my ex's batting average in Little League? This is very pertinent to the case. I need to know if he was lying to me the first day he met me, because it would explain a lot. Yeah, not gonna work. Not gonna work.
Children?
Oh, actually, on the January 27th?
Yes, or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Okay. Even though the order was for the 29th. Wasn't that the part
Whatever,
that the judge put
whatever
in
day,
place?
whatever judgment day,
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment that
And,
you slammed the door in my face. I have it on video, yes.
and you came alone, correct?
I did that day,
Okay.
yes.
And then, that's all. That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any?
Yeah, that was mom. With those incredibly useful questions that cleared up a lot. We know a lot more about what's going on now thanks to mom. She's a real benefit to keep around for the court process.
Testimony or witnesses? No? Okay. Check that order because there was some. Ms. Couch, you raised some issues concerning the I think it was the order of January 20th.
All right, this is a good time for everyone that rated from Big In and has not seen this yet today. I'll try to summarize what's going on. So this is Dad is Dad has an attorney. Dad's attorney filed a motion for contempt because mom isn't letting dad see the kids. She is intentionally keeping them from him and filing false CPS reports against him, calling the police. So she's doing everything in her power to keep the kids away from dad. All the investigations have come up negative, but the accusations she has against him are horrific. They involve exactly what you would think they would if I'm not even going to say it on stream. But so yeah, that's where we're at. So that was grandma that was just testifying. Dad just testified before her, and now we're about to get into the ruling. So this is I know a couple people have said it, but if you have people around, you might want to put on headphones because yeah, mom's about to say something here in a few minutes. It's gonna it's gonna earn her some free a free lodging. Let's just say that.
7th, I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups.
And why is that?
Because he has sexually abused our children, and I don't believe that he needs any more parenting time.
You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him.
I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
You guys did receive the pictures that I submitted to the court as well, correct?
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay, let me clarify that, because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. Do you have, that was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not, but you have not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So that is okay. Mr. Kelly, do you have any final argument in this matter?
As the court's already touched on a little bit. This is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With the threshold being met, Your Honor, And considering the behaviors, and I think it's gonna be ongoing from Ms. Couch. We request that the children be turned over to him today. That he have custody and parenting time with the children until the evidentiary hearing occurs. We request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely gonna take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request the finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's a voice she's never gonna.
I don't think he looks scared. I think he looks beaten. He looks defeated. That's a dad that's depressed because he hasn't seen his kids. I get it. I get it.
Pay doesn't have any impact on her. At this point in time, we request jail time, 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank
Okay,
you.
thank you. Ms. Couch, your closing argument.
I am acting in I just want my kids to be safe. That's all.
Okay, thank you. Well, the court has heard again, the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of.
But there's reason, sir.
Excuse me?
There's reason,
Okay.
valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify.
All right, here it goes, guys. This is the warning. I was a little early saying it about, I don't know, 7-8 minutes ago, but here we go. This is when it gets bad.
You had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four of those orders she's failed to comply with. The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time. And that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact, she has ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you paid the previously ordered attorney fees of $1,000. So, ma'am, you can go with the sheriff, and
Are you
This matter
serious?
is concluded. You're free to go.
Who's
Have a good
sucking
day.
whose dick around here?
Oh,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long as you want, ma'am.
Your Honor, if we could have the assistance of the sheriff taking out where the girls are, we suspect they're with their with grandmother, but we're not.
Well,
100%
she
sure.
has been remanded until such time as the girls are turned over, so that, she can stay there as long as she wants, I guess, until she has them turned over.
I'll draft the order in 7 days, Your Honor.
Okay, thank you.
Thank you, sir.
You're free to go. Have a good day.
Oh, yeah, that just happened. That just happened. You know, there are a few things you don't say to a judge, and then there are certain things that you don't say to, anybody. And yeah, that was her FAFO moment for sure. Um, what did she think was gonna happen? 60 days, Dad. Enjoy your time. Enjoy your time, and maybe you can file some motions to say that she's unstable because of how she conducts herself in a professional environment. She shouldn't be raising the kids. I'm rooting for Dad. I'm rooting for Dad. Okay. Let's see. We got legal fiction for 14 months. Legal fiction, that is awesome. Congratulations and thank you. I do appreciate legal fiction. And Hitchbot, thank you so much for the super chat. A few years back, my store had a freight manager that was arrested for fleeing the state with her kids when custody hearings were going bad. Yeah, you can get those stories from time to time. Not a good idea. You can get charged with kidnapping for that. Don't do that. Even though you're kids, they're your kids. You can get charged for kidnapping. Not a good look. Not a good look. Thank you so much for the super chat. I appreciate it. All right. We are moving on. We have this one. This next one is this next one's just weird. And I'm going to be honest with you. I was laughing probably harder than I should have watching this next one. You just get some people that have no idea what they're doing in court and just have all the confidence in the world. So this next lady is suing her former landlord for $20,000 just because that's what they're there for. It's a lawsuit of $20,000, and she didn't write a reason down why. So they're in court for a $20,000 lawsuit for reasons. All right. I did jack the volume up of this because the court's audio was really bad today. So because I jacked it up, you may have to turn it down. So just a warning ahead of time. All right, let's go.
Followed up after this case. Cause number 41S2400670. Chicky Brown. Versus Anna Latowski.
Yes, ma'am.
And I believe that the Latowskis are on Zoom.
I shall do.
Yes, this is Texas. I should have said that. This is Judge Garcia's courtroom in Texas. I think San Antonio. I think we figured that out. It's in San Antonio or kind of close to San Antonio, I think. This is not Judge Garcia, though. Judge Garcia hasn't been on the bench in the morning since I think the new year. It's been over 2 months. She has pro tem judges do her morning dockets, but she's always there in the afternoon. So I don't know what's going on with that. Sparkle Poots. That mom court case, that's a feeling. Oh yeah. Okay. That's a feel good clip is what you're saying. I got you. All right. But yeah, I can't have a 30-minute feel good clip though. That was a long one. It was a long one that took a long time for the payoff. Let's just say that. But Sparkle Poots, thank you so much for the super chat. All right, let's watch this one.
Ms. Latowski.
Yeah, Judge, we're here. Before we proceed, we have a motion in front of you for a summary judgment. The plaintiff never listed any cause of action or anything we can dispute or defend against. She's just asking for $20,000. She,
I did see that.
Yes, ma'am.
I did see that, Mr. Latowski. All right.
And they know.
But you didn't file anything. This is just a oral motion, correct?
Ma'am.
I'm talking to Mr. Latowski. Is this an oral motion or did you file something? Mr. Latowski, did y'all
Ma'am,
file? This is an oral motion for summary judgment.
we can't hear you.
How did they hear me?
There's no claim of facts. There's no reason for the case. He just arbitrarily asking for $20,000.
They forgot to do it, but house.
Can you hear me now?
I can hear you.
You can't. Okay. Well, my question was is that you didn't file anything in court, correct? It's just an oral motion for summary judgment.
Like you did.
He still can't hear. Oh, he did file something. Never mind. I see it here. The clerk just printed it out. I see what you're saying, that you have it for summary.
Thank you.
Okay, thank you. Let me, ma'am, it just shows you didn't put like a cause of action. You don't
Yes,
have.
I told that woman, ma'am, at that thing, December 13, that Alan and them had me and my kids and my old man repair the house. I'm a house. I'm disabled. And the woman, I thought she was gonna put everything down. I explained the
Ma'am,
situation.
there's nothing here. It's nothing. It's blank. Can you see it?
Yes, I know. I see that she didn't put nothing on there because I explained my whole situation when I paid $140.
Yes, ma'am, but you were supposed to write it, not her.
I did write it down. I did write it down.
Ma'am, looking at this, you have no receipt, you have no pictures, you have nothing,
Yes,
no
ma'am.
cause of action, no cause of action. There's nothing written in your complaint. There's nothing attached to the complaint. All it says is $20,000. And as you know, you're asking for the maximum
Yes.
that the court can give in a
Yes.
court. And, but there's no cause of action. So I'm going to go ahead.
No, ma'am. The
Yes,
woman,
I'm going to
the
tell
woman
you
told
what
me to
I'm-
bring everything.
Ma'am, you're not going to tell me how this court's run. I'm going to tell you. You were supposed to write down cause of action. You have zero cause of action. You're asking for the maximum amount, and that's not happening.
Okay,
That's not how it works.
okay.
So I am going to grant the motion for summary disposition, and you have 21 days to appeal. Okay? Thank you very much, and you may be excused.
Judge, we're also asking on a counterclaim.
I did.
You didn't file for the time, Mr. Latowski, so I cannot hear a counterclaim at this time.
Okay,
She
Thank you, Judge.
If she appeals it, then
Yeah, I had moved out their house. Now gotta come back to court March 18. That's why I wish they was there because I had to clean out their house March the 9th. Did everything I had to do. I got their house keys because they can have their house. I'm already out their house. That's
did
why-
she give you the keys back?
No, that's why we came to court because she filed on me March 18. I would get next week.
All right,
And I,
well, I granted the summary disposition.
yes.
Okay, and you had 20 to fill.
Ma'am, what do that mean? What do that mean?
thank you, Judge.
That
May we
means
be
you
excused?
lost the case and you're not going to get any money.
Okay, so can I repeal? Because,
I just told you you have 21 days. to
okay,
appeal.
thank you. And mama, one more thing.
Oh, there is
Thank
a
you.
claim. I'm
I
sorry.
know I did.
No, they filed.
Oh.
a counterclaim.
Well, can I get my deposit back then, please?
Ma'am, hold on, let me read the counterclaim. They just, the counterclaim, the $1,500 is for exactly what?
That's for housing. They took me out for housing, mama, and I paid $1,166 in September, October, November. They gave me $1,500. Anna owed me $888, Anna stole my money for January when she supposed to give me my money back, but for the $888. She had the permission now, $273 of my portion on housing, because housing was paying $887. I was paying $273. So housing took me out for housing, mama, when they weren't supposed to. So it was a big mistake. They put back on housing. They started back paying Anna. Proof that they started back paying Anna. Anna lied told me they weren't paying her. I went to housing. They told me and showed me everything that they, as you see you go right here. They've been paying Anna, ma'am. She cannot come in. They have been paying her. So Anna supposed to gave
Okay,
me.
I'm signing the, I'm granting the summary disposition.
No, mama, she
The
gave,
counterclaim.
she gave me
Saying
$1,500.
nothing on it.
Okay.
Keep talking. You need to stop talking, please. I'm trying to make a decision here.
Okay.
You just talk over me. You're being.
I really apologize.
It does show that y'all were getting money,
Mm-hmm.
right here, through November the 27th of 2024. So what I'm going to do, the board is going to grant the motion for summary disposition, and the counterclaim will be a take. Okay, y'all, each side has.
Thank you, Judge. Can we be dismissed?
Yes.
Yes.
Okay, dismissed. Have a great day.
Thank you.
Yes, I'm gonna do it right now.
Okay.
Thank you, Mama.
She's-
Cost number
Lady,
45 Michelle
I'm gonna feel, thank you.
Zola versus Roxanne Garcia.
Threw her out.
Yes, ma'am. 1 second.
All right. Yeah, I don't know if you heard that, but the I don't know what you would call her. The ex-tenant said "F you" to the bailiff as she was walking out. So she's a very classy lady. Yeah, we're gonna just file a $20,000 lawsuit. Just put it on a piece of paper and submit it. Cost her $140 to submit this for whatever reason. I don't know. But the judge was nice to her. She did a take nothing judgment on the countersuit. So there's that. So she doesn't owe any money. All right. Let's move on. Now we're gonna head to Judge Simpson's courtroom, and yeah, we get there's nothing really to explain. It's Judge Simpson's courtroom, and we may or may not get a Mr. Allen, and it might break your heart a little bit. Let's go.
Court calls case of the people versus Judge Jane, I think Martin.
Johnny.
Okay, no, I did that the last time. You were much nicer about correcting me this time, but come on.
Good.
Said it nice this time. The last time it was like I had insulted her whole family. Anyway, go ahead.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Martin. Miss Martin, please state your name again. Johnny Martin.
Tracy Poyer on behalf of probation. Your Honor, Ms. Martin is before the court for a violation of probation hearing. Ms. Martin has been on probation for 2 years for a reduced charge of assault and battery. In this case, Your Honor, Ms. Martin has made no payments to the court. Her balance is $1,530. Probation has failed to receive completion of the CPS Family First Program and Parenting class. Ms. Martin also failed to report to probation after April of 2024. And Your Honor, her probation term is maxed in this case. Given that these items were not completed, probation is recommending that Ms. Martin serve 93 days in jail with credit for 1 day served, that she served the balance, waive remaining terms, accept the financial obligations, and discharge her from probation.
Ms. Perry.
Your Honor, I was able to speak with Miss Martin about these issues. She believes that she did complete the CPS and parenting class. She's been trying to get in touch with them for the last week or so to get proof of that. She has called the case manager that was on the case. She no longer works there. She gave her another number at CPS. They told her they would call her back. It's kind of been, thwarted by bureaucracy. So I'm asking to adjourn this hearing out a bit so she can continue working on that. Again, she remembers completing it, but it has been.
There is one sob sit that's supposed to return tomorrow. I don't want to say it because it's a smaller court, and if I say it, then just magically people are going to be staking out that courtroom tomorrow. So I'm not going to say it, but there's a sob sit returning tomorrow, and it's not the jury trial going on right now with Judge O'Donnell. Different sob sit. So hopefully we'll get that one tomorrow.
That information get to probation.
Frankly, Your Honor,
I can tell you why, because she never reported to probation.
She did. That is the allegation, Your Honor. Around the time that this was all happening, the father of her 2 youngest children was killed in Washtenaw County. And I think she's a single mother. That kind of, greatly affected her life. And she's been dealing with the repercussions of that since that happened in June of 2023. So she wants to get proof to probation. She's just having trouble doing so.
What about payment? I have no payment. I have no reporting to probation. I have nothing.
I just started working out.
I don't think there was a Mr. Allen said by Judge Simpson. What I think happened is when Miss Polera recommended 93 days in jail, I think that's when he went behind her. There wasn't a Mr. Allen, so we all missed it if there was. Hey, what's up, Shane? Good to see you.
She has 5 children?
Yes.
5 children, 11, 8.
11, 9, 8, 3, and 1.
So she, for a long time, didn't have childcare to care for her children and work.
I just started working. I can't make a payment when I get my check. It is
How come
hard.
you didn't report to probation?
I don't know. Like I had after my child's father passed away in my apartment complex, I just shut down. It was real hard on me.
I get all that, but I guess the last time you were before the court was in February. You're going to pay the fines and costs by March 3rd. No payments. You would report to probation. No reporting to probation. I'm assuming you were supposed to complete the Family First program and parenting classes. I don't have any proof of any of that.
Yes, I completed it. I went to Orchard's Family, Children and Family Services. I think that's what it's called.
When?
I finished that class in 2023. I just didn't report it.
So you're saying that was completed before I sentenced you?
Yes.
I can try to look to see what the prosecutor's office may have.
What the prosecutor's office may have?
Yeah, I mean, maybe it was provided to them to reduce the charge, as this charge did originate as a child.
Anything else from anybody?
Nothing from me, Your Honor.
Do you have anything else you want to tell the court?
I was just give me some time to make the payments. I'm all my kids got. I don't really want to go to jail. I'm already have.
Should have been keeping in track with probation.
Right.
You just didn't do anything.
I know that I did. I know I did.
Okay, so here's what I'm going to do. I'm going to waive the remaining terms except for financial obligations. I'll discharge her from probation without improvement. What I am going to order is that she's to serve 93 days in jail. I'll give her credit for the 1 day. She's to serve the balance. I will strongly consider release if I get proof of completion of that class. All right, you're still going to owe the money. You need to set something up with the court. You're going today, but But if they get me proof of that, then I'll consider release. I'm not guaranteeing that I'll release you, but at least I could have something to look at that says you did something.
Okay, can I at least can we call the people?
Call which people?
For the,
You can talk to your attorney. We could figure out a way to make the call, but right now you're going. Defendant's remanded.
No, I did not freeze, Terrapin. I am still here. I'm still here. No freezing. No freezing. All right, I'm gonna do something different tonight. I do have one more Judge Simpson clip, but I'm gonna play something. I'm gonna play for you guys the video that I released this morning, because the video from this morning, the likes are just not the likes. The views are pitiful on the video, and I'm gonna guess that most of you here have not seen it yet. And it was such a good clip. I want you guys to see it. I know that my audiences for my videos I release in my live streams, they don't really mix. It's you either watch the videos or you watch the live stream. Most people don't watch both, which is fine. But if you have seen this, you're in for a treat because I'm going to play it again. But you guys have to watch this. It was a random clip that I found. I found the virtual directory of the state of Washington, and I started going through all the courts that I haven't seen. And I found a lot of courts that still have all of their court videos up. They just don't stream anymore from back during the pandemic. So I was just going through a couple of them, and I found this gem. So I know I see you guys. I appreciate you guys that watch both. You guys are awesome. I love it. I love it. But I want you guys to see this for those of you that haven't seen it. And but it is awesome. Hold on, I got to figure out how to do this. Share screen. All right, here we go. Full screen it. Here we go.
In the motion to revoke still. And I'll call up Daniel Tart next. And this is 513-41604.
Yes, ma'am.
On arraignment. Good morning. And 602 on a motion to revoke.
I just wanted to state ahead of time.
Mr. Tart?
Yes, sir.
Let's hold off on the commentary.
No, actually, I want to say something because last time y'all stopped me multiple times for saying something. And I'm not going to have it happen this time. Not trying to be a dick or nothing, but my paperwork was stolen from me this time. And I want y'all to fair warning to know that.
Thank you. So, Mr. Tart, I'm going to just go over the arraignment documents with you, which is the criminal complaint, and then also a motion to revoke that's been filed by the prosecutor's office. Okay, so if you can just bear with me, I'm going to go over that. And then if there's information you want the court to know in addition to what you've already provided, then you'll have an opportunity to speak to conditions of release. So this morning, the charging document that you should have in front of you has one count of violation of a court order.
Yes, ma'am.
And that alleges on or about the 29th day of May, 2022, in the city of Bremerton, in the state of Washington, that you did with having knowledge of a Kitsap County District Court order previously ordering you that there was a protection order in place, a restraining order, and no contact order against Crystal and Mitchell, and that you did violate that restraining order.
No, they never caught me around her. Incorrect.
Okay, I understand that you're denying that it happened, but this is what is alleged. Okay, so you don't have to agree with it, and I'm not asking you to agree with it. What I'm asking you to do is to just let me get through. Okay.
Sorry about
and
that.
This occurred. Thank you. And this is an occurrence that is contrary to the Bremerton Municipal Code as adopted by the RCW. This carries a maximum penalty of 364 days in jail and a maximum fine of $5,000. This allegation, the count one, the violation of a court order, has a special allegation that this occurred against an intimate partner. And the court has reviewed the Bremerton Police an incident report, an investigative report that is set out here, and finds that there's probable cause that there was a crime committed. The motion to revoke is dated May 31st, 2022, and it is an amended motion to revoke, and it has 2 allegations in it: non-criminal law behavior, and that has charges from the Kitsap District Court, which occurred in January of 2022, and then the current charges that I've just gone over with you in the criminal complaint, as well as failure to provide proof of evaluation and treatment, and that evaluation and or treatment is considered anger management. So those are the allegations that have been set out. Present on Zoom to assist with this process is Mr. Claridge, and the information as far as what your financial status, has anything changed since you were last appointed counsel?
Oh, nothing's changed. I'm still homeless and I still have no income.
Okay, thank you. So previously, in your underlying charge that is ending in the cause number 602, the Lacrosse Murphy firm represents you, and I would appoint them to represent you in these matters as well. And understanding that with the charge, the motion to revoke, that you're presumed to be and have not violated the conditions of your release or your JNS until the allegations are proved by a preponderance of the evidence, unless you admit to those allegations.
No,
so
I
Mr.
don't
Claridge is gonna, okay, so Mr. Claridge is gonna assist with the remaining part.
All right, so far so good. He said he doesn't admit he is in front of the judge for a motion to revoke his bond because he violated a protection order. Just wait until you hear his side of the story. Yeah, spoiler alert. He doesn't want to admit to it, but he admits to it. This is why you don't talk.
Part of the arraignment at this time.
Okay.
Thank you, Your Honor. We'd ask to enter a denial and a not guilty plea for Mr. Tart at this time and set dates on the new matter for pretrial. Thank you.
Thank you.
Is there any
So
way
the record
today?
the record will reflect denial to the allegations set out in the amended complaint dated 5/31/2022, and the record will reflect the not guilty plea to the criminal complaint that's been filed in the matter ending in 604. I'll hear from the city as to conditions.
All right, real quick. Headphone warning. We're about to get some really bad language and some loud noises here in a second. So, yeah, small ears and headphone warning.
Thank you, Your Honor. In the new case ending in 04, the city is requesting $2,500 bail. I've listened to Mr. Tart this morning, his comments to the court, but an officer, Jeffrey Schaefer, observed the two parties together at a local agency on May 29th as the allegation. So contrary to what he's saying, the city believes
So can I ask you one thing? No.
there is sufficient facts.
Bus, they're gonna throw me on the bus. If they saw me in the same, no. If they saw me in the same area, that is both a business. We are both allowed to go with that business together. Maybe she.
Mr. Tart, please do not talk on the record at this time. Please.
Oh shit! Y'all trying to hit me up for fuck ass charges I didn't fucking do. I ain't never been around that stupid ass bitch. Fucking white ass shit. Fuck ass motherfuckers! Charge me now! Motherfucker, they trying to fucking tell you that I was around her. I never was around that bitch. I never was around that bitch. Don't shove you, you stupid ass cunt. Bye. Fucking shove you. Bye. That bitch. Cause I showed you the bitch at the same time you come up with this shit.
He's in crisis 3.
Shove, shove, right?
At the table.
Let's see this.
I can get that stuff.
Defense is going to reserve bail arguments on this matter.
Would the court mind muting us for a minute, please?
I'm asking for $5,000 bail on the.
So, Ms. Harvey, let it go right now.
Oh, weird. That was weird. I just stopped sharing my other screen and I heard myself talking. It was weird. All right. Yeah, that was the video I played this morning, and I absolutely loved it. Hope you guys enjoyed that. Sorry for the language. And yeah, I love that part of his bond violation was that he didn't do his anger management course. Yeah. Yeah, apparently someone needs to take their anger management a little bit more seriously and do it. But that one was fun, right? All right, let's move on to the last clip of the night. We'll just move on from here. Okay, I thought I saw something. I thought I saw a chat that I think I just made up in my head. All right, move on to the last clip of the night. You're welcome for that, by the way. Last one, we're going back to Judge Simpson. Let's go.
Court calls the case People versus Chance Stallings.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stallings, who's
Yeah, I know we're all adults here. It's court content. You know, there's kids don't watch court for fun. I know everyone's an adult. My worry though is, especially because I don't curse that often, that somebody might be playing this on their TV or their laptop with kids in the background. That's why I give the warning, just so the people with little ears around them have a chance to rectify the situation. So that's it. I know we're adults.
stands to my right. Please state your name for the record, sir.
My name is Chance Stallings. Good morning, Your Honor.
Teresa Claire on behalf of probation. Your Honor, Mr. Stallings is before the court for a violation of probation.
Take your hands out of your pockets. Go ahead.
Mr. Stallings is non-compliant with the terms ordered by this court in that he owes a balance of $1,725. His last payment to this court was made in January of 2024. He failed to provide proof of substance abuse treatment. He failed to provide ongoing proof of mental health treatment. Mr. Stallings, to update the court, did provide me with some documentation, but that was dated in 23. So it's nothing that is updated or a status report that anything continued. He failed to report to probation as directed. He would contact me sporadically throughout the term, but nothing consistent like he was supposed to. Mr. Stallings also has a new pending criminal case of domestic violence and an assault out of Toledo. That alleged date of offense was February 20th of 2024. He failed to appear on that case and is in bench warrant status there. He has matched the 2-year term in this case. Given all the violations before this court on this matter, probation is recommending that Mr. Stallings be remanded to serve 365 days in jail with credit for 77 days served, that he serve the remaining balance, that he complete the in-jail Dawn Farm program, waive remaining terms, accept his financial obligations, and discharge him from probation without improvement.
Response.
Thank you, Your Honor. I have had course, the opportunity to review the allegations as well as the recommendation and discuss them with Mr. Stallings. I guess I will just address each one by one. We do acknowledge that there is that balance owing. My client states that he could make the payment in full today. We do also acknowledge that the substance abuse treatment was not completed. However, my client does state to me that he has been on his own attending NA meetings and that he is on a waiting list through his insurance for the mental health to get into the substance abuse treatment program. He relays to me that he's been on a waiting list for almost 2 years. He did provide that documentation from 2023 that Ms. Polero referred to. We do acknowledge that the reporting has been sporadic. Mr. Stallings states to me that during his time on probation, he experienced homelessness for quite some time. So he often didn't have access to a phone, or he didn't have an ID to be able to go to the library and use their computer to try to do the online monthly reports. He does acknowledge, and there's no arguing that, yes, his reporting was very, very sporadic. And he does acknowledge that a lot of it was because of his housing insecurity and homelessness. He does also acknowledge that there is that new case. As of right now, they are just allegations, and he does believe that he will be found not guilty upon the resolution of that case. Ultimately, we're asking that the court, when I do also want to mention, my client also suffers from narcolepsy, and he has been applying and trying to get SSI. We are asking that the court, because we do acknowledge that the probation term here is maxed. I'm asking the court to discharge him from probation without improvement, waive the remaining terms outside of the financial, which he states he could pay the balance in full today, and not impose the jail time, given the fact that he has dealt with some serious housing insecurity and does have a health issue. And in the alternate, if the court was to impose the jail time, I would ask if the court would consider early release upon the completion of that in jail Dawn Farm program. Outside of that, Your Honor, that would be my request.
Anything you want to say, Mr. Collins?
Your Honor, I had a pretty unbalanced last 2 years. The first year I was pretty decent with reporting and keeping updated with Ms. Polero. Once I fell into homelessness, I really fell off track. I've recently started improving again. I have a job. I work at Speedway. I recently got a tax refund, which is why I'd be able today. Your Honor, the defendant in that case is present in the courtroom, and we're the one that's out of Toledo. We're working on getting it dropped. It's just a really tedious process with the clerk's offices out there. She's trying to contact the prosecutor to set up an account. As I said before, I'm just trying to be a better man for my kids, and I understand that I have and take accountability that I haven't been in full compliance with reporting. I've been doing the best that I can, Your Honor, and I'm at your mercy.
Well, there's not a lot else I can do. I will order that he, once remanded, is to complete the in-jail Dawn Farm program. I'll consider maybe circumstances of his release at that point in time. I'm going to waive the remaining terms except for financial obligations, discharge him from probation without improvement. I am going to sentence the defendant to 365 days in jail, credit 77 days served. Defendant at this time is to serve the balance. Defendant is.
All right. That's it, guys. That's it. That's all I got. Thank you guys so much for hanging out with me tonight. I appreciate it. Biggin, once again, thank you for the raid, and thanks for all the raiders that came over. Yeah, you guys are awesome. Thanks for the super chats and gifted the membership milestones. I think that was it. Oh, I almost missed Mary. Mary, I almost missed you. Thanks, Mary. I appreciate it. I don't know if you guys caught this, but a few minutes ago, I kind of made this weird pause, and I said I thought I saw something because I thought I saw a milestone, and I did. I just didn't look hard enough when I was skimming back to it. Mary, thank you so much for the 13 months. That is awesome. I appreciate it. All right. Yeah, again, that's it. We are going to we're raiding KFAR tonight. We did KDZ last night. We'll do KFAR tonight. I feel bad because I really wanted to raid Lone Wolf, but it's Wednesday. And I thought last night was Wednesday and we raided KDZ, but tonight's Wednesday. So we're gonna raid KFAR tonight, which means I'm raiding Lone Wolf tomorrow night. It's happening. It's happening. So if you guys want to go hang out with Lone Wolf, he's on. KFAR and KDZ are doing booze and body cams. And I think that's it. I think that's all I saw. At least on my list. I will see you guys tomorrow. Yeah, that's it. Have a great night, everyone. Until next time, bye.